Yes, Mr. Clinton.
Before I come to my submissions on the 2024 regulations, my 4 points, can I just come back with my homework over lunch?
Yes.
We all think there's no definition of occupier or occupy in the 1967 Act. In response to Justice Holgate's question, there is a definition of owner and hereditament, but not of occupier.
So it doesn't refer back to the old case law.
It refers back to the old case. No, it doesn't.
For the purpose of occupation.
It doesn't expressly do that. It doesn't have the equivalent.
On the other hand, Cardtronics in the Supreme Court, I thought recently.
You've got Cardtronics in here.
They do that in it's tab 26. And it's really section 65(2) and the point, but it does cover the point you were dealing with this morning about the rules.
Yes.
And it says that the rules include the John Lang criteria.
Yes. That was the point I was trying to make earlier.
It came across differently, but it's dealt with in 13, paragraph 13 at page 373 of the bundle. But you're saying there was nothing in the 67 Act itself which invoked the case law.
Yes, I apologise. I hadn't. I had highlighted paragraph 13, but I hadn't recognised that it referred to them as rules.
Yes.
So yes. I take my law's point.
Yes.
So the rules include Lang as I submitted,
Yeah.
but I say they're not exclusive. Lang, it includes Ramsay. That was that point. If in terms of whether the discretion was removed earlier than 1988, we're almost certain it wasn't, because we've been through all the repeals and then I made a mistake on industrial hereditaments and how they played out. So they in 1966 and 67 they were in what started with section 21(1) as all hereditaments effectively. So they were in that and they were subject to the 3 months. In the 1989 regs, they were in. They were treated as an exception, but there was no time limit. So in other words, an empty industrial property was exempt for whenever it was empty. And then in 2008, the 6 month limit was imposed. So I wasn't correct to say that the 1989 legislation was all a hardening. It was to that extent it was a lessening of the liability for industrial hereditaments. And I can't assist as to what drove that, I'm afraid. I hope that answers. That's the homework. Well, I'm now going to make my submissions on why the 2024 regs don't assist. First of all, our headline case is that.
Sorry, just going back to the very first of these points, section 65(2), which is in the 1988 Act, are we saying it did not have a statutory equivalent in earlier
Yes.
acts?
Yes, and we're going to check that overnight. But yes, that is what we're.
So that's the first time you see that sort of word.
Yes. But subject to the caveat that I will come back to you if I'm wrong.
Of course.
Thank you. So on the first point we make is that there is no ambiguity, and so the principle that all justice being is referred as to doesn't apply at all. And the reason there's no ambiguity is because Ramsay resolves it for all the reasons I've been through already. The second submission is that it doesn't apply. The principle doesn't apply because the 2024 regs do not fix the meaning of occupy. All the cases that the Benyon referred to are where the only way of reading the new legislation is that it proceeded on a particular interpretation of the old, and so that resolves the latter legislation resolves the ambiguity. But here, the legislation only changes the period to which the occupy is attributed. It does not do anything to the word occupy or tell us anything more about what occupy means. So it doesn't fix, in the sense meant in the authorities, the meaning of the term. The third point is that in any event, the 2024 regulations cannot fix the meaning of occupy because the meaning is fixed by primary legislation. And the reason I say that is as follows. I've shown that Regulation 5 is a direct successor to Schedule 1, Paragraph 1(3), which was the reset provision, the primary legislation reset provision.
Sorry, Schedule 1,
Paragraph 1(3) of the General Rates Act.
67.
Of the 67 Act, yes, yes.
Which in turn succeeded Section 21.
Which in turn just covered, so it goes right back to the original statute. The statutory purpose carried through,
Yeah.
so that was always in the primary legislation. When Regulation 5 was adopted, the purpose of it and the wording of it is exactly the same. There's no change in the purpose or wording of Regulation 5. And therefore, it can't have a different meaning from what it meant in the primary legislation. And therefore, we need to look at what occupy meant at the outset.
I thought you were going to make a slightly different power, which is a point, which is that it would have been out with the regulation making power.
That's going to be my next point.
Okay.
No, I said this.
I'm not sure this is a separate point, but I probably haven't understood.
Well, it may not be. It may not be. But the point I make is that you have to construe occupy by reference to the primary legislation, what the purpose of it in the primary legislation and the words in the primary legislation, because it's all just followed through. It's just a continuum. There's no change in 1988 when it goes into the regulations. But of course, the 2024 regulations can't change what occupy meant in the primary legislation. That's the Knight case. Secondary legislation can't change the meaning of primary legislation unless there's some particular ability within it to do so.
No, well, that's standard, but what is the provision in primary legislation which you say it would have been ultra vires to amend by secondary legislation?
This all goes back to where the word occupy comes from. And so it started as the word occupy in 21 subsection 3. That was carried forward without any changing in the word or any intent to change the word in the 1988 regulations. Therefore, the meaning is the same as it was in the primary legislation, and regulations can't change that meaning from the primary legislation.
But yes, but what was the meaning in the primary?
That begs the question. I mean, what I'm saying is at this stage is that this is about whether you can help with whether the 2024 regs can assist. And my point at this stage is that the 2024 regs can't assist in the interpretation because it's a matter of primary legislation where occupy has to be understood.
You said 21.3. Do you mean 21.4?
21.4. I mean, yes. I apologise. I do apologise. That was the first point under section under the regs. It can't fix. But the second point is this: that the section 65(2) fixes the meaning of occupation and does not empower regulations to change it. And we know it fixes it by reference to what went before, into the Lang and Ramsay. That's what it says. Therefore, any attempt by regulation to change the meaning of occupy is contrary to section 65(2). Now, that's not to say that conditions couldn't have been added. Of course, conditions have been added. They could say, yes, occupy means the same, but occupation of this particular polity doesn't count. My point is that none of this assists on the meaning of occupy. My last point is that this can't mean what my learned friend says it means, because it would be out with the overarching purpose. I therefore move on to point 7, which is just a short submissions on some other matters that have been raised by the judge and elsewhere. First of all, legal certainty. This is addressed in Hurstwood at 60 and 61. At page 453 of the bundle. Top of 454, ultimately the principle. The value of legal certainty does not extend to construing legislation in a way which will guarantee the effectiveness of transactions undertaken solely to avoid the liability which the legislation seeks to impose. So even in that context, where the person entitled to possession was a well-established term of art, legal certainty allowed you did not require one to adopt a meaning contrary to the statutory purpose. And my learned friend says, well, it creates all sorts of problems for the courts if there's any lack of certainty. I have a number of answers to that. First of all, on my formulation, there's no problem. This turns on the solely for the purposes of rate mitigation, our case here. And the lower courts are well used to dealing with such matters, if necessary by cross-examination. Here, of course, no need because of the agreed statement. And my lady in Emeraldshaw will have seen the district judge's extensive consideration of the matters there on the facts after cross-examination, to establish the facts and then to apply the legal principles to them. So there's nothing in rating any different from any other area of the law. If you have to find facts, you have to find facts. My learned friend has referred to the absence of any legislation to create a general anti-avoidance rule. That's my next point. And he's included in the bundle the Welsh provisions that do allow for a general anti-avoidance rule, and I'll hear what he says about those in due course. But the fact that a general avoidance rule has not been legislated for here and has been elsewhere does not assist. And that's because the Supreme Court of the House of Lords said so in Ramsay. Now, if we go to Ramsay, please, it's page 124 of the bundle. I'm picking it up at 124 of the bundle. Letter H. The case had started its history through the courts just on the interpretation of the legislation, but in the House of Lords, the Revenue mounted a fundamental attack upon the whole of the scheme. It contended that it should simply be disregarded as artificial and fiscally ineffective, and that was the radical departure that was then referred to in various of the submissions. The court dealt with the argument on the need for general avoidance rule at page 128. And what my lady, my lords, will see at F to H, that if there was going to be this radical departure, rejection of accepted and established canons and so on, then that was a matter for Parliament, it was said. The function of the court is to apply strictly and correctly legislation. If the taxpayer escapes the charge, it's for Parliament, if it disapproves of the result, to close the gap. General principles against tax avoidance are for Parliament to lay down, is what it was said. And that was this House of Lords then asked for examples of general avoidance rules, and there were a number that were referred to. Indeed, if we go over to page 129, there was even a value shifting capital gains tax act, section 25, which would have impacted the Ramsay scheme. So later in Ramsay, there was a general avoidance rule that would have attacked it. But even in all of those circumstances, even though there were general avoidance schemes elsewhere, and even though later here there was an avoidance provision, that did not disapply or mean that the Ramsay approach should not be adopted. That's at 129B to D. Indeed, it was effectively the role of the court to do so. It would, to do what the court ultimately did would be to apply to new and sophisticated legal devices the undoubted power and duty of the courts to determine their nature in law and to relate them to existing legislation. When the techniques of tax avoidance progress and are technically improved, the courts are not obliged to stand still.
Where are you? Sorry, where are you? Oh, yeah, I've got it.
129B and C.
Yeah.
The courts are not obliged to stand still. I'm sorry, I've now lost where I was reading from.
Just above C.
Such immobility must result either in loss of tax, the prejudice of other taxpayers, or to parliamentary congestion, or most likely to both. To force the courts to adopt, in relation to closely integrated situations, a step-by-step dissecting approach, which the parties themselves may have negated, would be a denial rather than an affirmation of the true judicial process. In each case, the facts must be established and a legal analysis made. Legislation cannot be required or even be desirable to enable the courts to arrive at a conclusion which corresponds with the party's own intentions. So you don't need a general avoidance rule to stop these schemes from taking root. And I have two further points. First of all, the judge below at paragraph 90, if perhaps the court could turn that up very briefly. If my lady will see paragraph 90, properly understood, it seems to me that the statutory purpose, whilst directed at bringing unoccupied properties back into use, also envisages providing scope for ongoing support, thereby opening the door or leaving the door open I can't see where the bracket's in. Leaving the door open, given the legislature's documents before under the 2024 regulations expressly recognising that RMS were already operating effectively. So leaving the door open for RMS is such as this one. So effectively leaving the door open for the RMS. The court proceeds on the basis that Parliament was intending to leave the door open for an RMS such as this. And but of course that can't be right, because it's contrary to the statutory purposes, and Parliament can't have allowed the Secretary of State to regulate contrary to the statutory purpose. So the space, the legislature deliberately leaving space for RMSs is just wrong. And then it's also said that we can test this by reference to what would have happened if this occupation had happened pre-1966. Would it have been occupation? That's not a proper basis to uphold the RMS, because first of all it's based on an impossible counterfactual. Prior to 1966, there could have been no intention to occupy for occupation's sake, because under the legislative scheme that would simply result in you being exposed to liability, not the other way around. Secondly, the business model did not exist of occupying to occupy, did not exist because there was no legislative or real world need for it. So the situation simply can't arise. But even if all of that's wrong, I would still be submitting in 1965 if this scheme was in front of me, or if I was addressing a case in 1965 on this scheme, the same argument would arise, that this still cannot be occupation on a purposive approach. So I don't accept that part of the reasoning of the judge either. Those are my submissions all on ground one. Unless I can assist the court further.
Thank you very much. Celine.
My lords, my lady, Mr. Fawley's submissions have proceeded predominantly on the assumption that the land criteria for rateable occupation are met. So I will now be addressing the situation under ground 2 with the submission that the land criteria, specifically land criteria 3, isn't met in circumstances such as the present. This is the alternative basis on which the City of London submits the court below erred in concluding that rates mitigation schemes operated by POL in this case were effective to trigger repeating periods of empty rates relief under the 1988 Act and regulations. In terms of our ground 2, it's really encapsulated at paragraph 5b of our skeleton argument. That appears in tab 2 of the law bundle, page 19. And it's essentially this, that the necessary ingredients of rateable occupation have to be present independently of the statutory consequences of that occupation and the rates mitigation effect, and not as here, only being present to secure the rates mitigation effect. Or to put it more colloquially or in a slightly different way, that there would be rateable occupation of the properties at issue in this claim by POL in a world where regulation 4A and 5 did not exist. And so I'll now carry on to make good bar submissions that we say for schemes such as the present, we say the land criteria are not met and there is not rateable occupation, as that term is understood. So we don't even get to the statutory scheme and whether the Reg 4A is in 5 triggered. In terms of the structure of my submissions, I was going to deal with it broadly in 4 parts, and I'm conscious a lot of ground has been traversed this morning, so I'll try and cut down the parts appropriately. The first is to just very briefly recap on the key criteria of this scheme, which are material specifically to the benefit intention issues which are raised under ground 2. I'm then going to go on to look at the Francis case, the Francis and Cabbage Hotel case, which we say is clear authority for the proposition that the relevant intention or benefit required for rateable occupation must exist, absent the statutory scheme of which it seeks to take advantage. The third part of my submissions, I'll turn to the key reasoning of the judge below and address why we say the judge erred in his analysis and conclusions. And my submissions on that cover four points. And then finally, very briefly, any additional points arising on the judgment or POL skeleton, which I haven't traversed or ended up picking up during my
Sorry,
submissions.
Ms. Lean, what was point 3?
Point 3 is the key reasoning of the judge below,
Yes.
and why we say the judge erred in his analysis, and I have 4 headline submissions under that ground. And then just finally, to the extent I've not ended up picking them all up under my earlier submissions, I'll pick up any additional points on the judgment or POL skeleton. So in terms of the key aspects of the scheme at issue, Mr. Fawley's obviously gone to the agreed case summary and the details of the scheme this morning, but the points I would just highlight are threefold. It's paragraphs 9A to 9C of the agreed case summary, which you have behind tab 1 of the supplementary bundle, and 9A to 9C here at pages 4 to 5. And essentially these are core facts, as it were, that I'll be referring back to on the question of benefit and intention, 9A, that the placing of the boxes is solely to attempt to generate occupation for the purpose of Reg 5. B, that the placing of the boxes and their contents in the premises serves no commercial or business purpose save for rates mitigation, which is the business purpose of POL. And C, that the benefit of the, quote, occupation is solely the claimed rates mitigation benefits. So those are the 3 points in the agreed case summary, and to add to that a fourth, which is over a pulling together of those points. And what that means in effect is that the realisation of any benefit in this case is dependent upon the rates mitigation scheme operating, so as to engage the relief in Regulation 4A when read with Regulation 5. And just to highlight that, if I may, again, just by reference to one of the factual documents before the court, which I'll be cross-referring back to in my submissions. And that is the terms of the contract between POL and the landlord.
Mr. Forsdick showed us this is not. If this doesn't work, you get your money back.
Indeed, my lord,
Yeah.
that is the point, and it's just to highlight that it's that point that it's yes. If its occupation is sufficient to trigger, it gets a benefit or reward in the form of a rate sharing, but if it doesn't work, then they don't get anything. And in fact, they're in a worse position because they have to pay the business rates that accrued during their period of occupation. Now, if I can move on then to the case of Francis, which is behind tab 24 of the authorities bundle. Starting at page, sorry, forgive me, tab 25, starting at page 345. And in terms of the relevance of this case as a headline point, we say it's clear authority supporting the City of London's position that occupation simply for the purpose of trying to engage the rates exemptions provided for by the statutory scheme does not constitute the requisite intention or the requisite occupation for the purposes of that statutory scheme. Now, this was a case under the 1950, Landlord Tenant Act 1954. I'm not aware of if the court's familiar with it or has had a chance to read it, or if it'd be helpful to me to give a brief recap of the key aspects of that case. But essentially, it turned on the construction of the word intention in section 31F of the 1954 Act, which is the section that specifies the grounds on which a landlord can resist a grant for new tenancy to an existing tenant. And essentially the facts of that case were relatively stark, because what had happened was the landlord made no pretense at all in that case that yes, he was going to carry out this scheme of works, we'd drawn up this scheme of works, but the only purpose of doing so, the only thing he wanted to get out of it was to get rid of the tenant and resist a new grant of a tenancy. And if it assists, the relevant factual summary can be found at paragraphs 5 and 6 of that case on pages 357 through to 358 of the authorities bundle. I don't propose to say any more about it than that, because that was really the crux of the debate that then had to happen before the Supreme Court, which was, well, essentially, is that a sufficient intention? Is that the right sort of intention to redevelop for the purposes of section 30 subsection 1F? And so thus, in terms of why we draw the parallel with this case, is that obviously in Francis what was being looked at was a statutory word intention there in a particular ground. But obviously, as has been traversed this morning with Mr. Forsdick, here, although we may be looking at things like the land criteria and common law to give us some understanding of what's meant by racial occupation, that does all fall under that statutory.
I'm not quite sure, well, maybe you'll persuade us that this case is as helpful to you as you think, because the decision was, it wasn't really, it was effectively a conditional intention. It wasn't, we're going to disregard this intention because it's not the right, it's done with a view to getting around the rules. it was much more straightforward than that, wasn't it, in terms of the reasoning? But I've not spent very long on it.
Well, my lady, it is helpful for me to come to the reasoning. It's helpful perhaps just for me to start with the way that it was, the question for the court was formulated by assumption at paragraph 1 of the decision. And it's that's at page 356. It's between D and E. And it starts, the question which arises on this appeal. It's whether it's open to the landlord to oppose the grant of a new tenancy if the works which he says that he intends to carry out have no purpose other than to get rid of the tenant and would not be undertaken if the tenant were to leave voluntarily. And in terms of how that then follows through, at paragraphs 9 to 15, and I say this just more by way of a way marker, starting at page 359 through to 361, the courts traverse the Court of Appeal and House of Lords authority as to, well, what does that word intention require in section 30, subsection 1F, and arriving at the two-stage test, a key one being that there was a genuine intention to essentially to demolish or reconstruct the premises. And where the court then gets to at paragraph 16 is to identify that the touchstone of ground F is a firm and settled intention to carry out the works. And it goes on to say the landlord's purpose or motive are irrelevant, save as material for testing whether such a firm and settled intention exists. So it wasn't the court saying, well, the fact that you're purely doing this for the motive of getting the tenant out means you're outside the scheme. What it was looking at was this question of, so a bit like here, it's not about, well, what's the purpose if you're doing it? It's, well, let's look at what's actually meant by the quality of occupy. And despite that, those points about the motive, as Lord Sumption says at the end of that paragraph, right at the bottom of page 361, those considerations about things like, well, landlord's got an interest in doing this, motive's not the driving reason, don't avail the landlord on the facts of the present case. And the key point that I draw attention to start with, my lady, is at paragraph 17, and it's the second, it's particularly the third sentence of that, but if I may, that Lord Sumption is saying the appeal doesn't turn on the landlord's motive or purpose, nor on the objective reasonableness of his proposals. It turns on the nature or quality of the intention that ground F requires. The entire value of the works proposed by this landlord consists in getting rid of the tenant and not in any benefit to be derived from the reconstruction itself. And that's the sort of the first hook, if I may, on which I draw the parallel with this case, because we would say obviously in this case the entire value to the to Pole of its occupation of the premises turns not on the occupation of the premises, the equivalent of the reconstruction of the grounds. It is solely about trying to take advantage of the mechanism in the statutory scheme to trigger the recurring.
So what's the proposition you get from this case, which is transferable to the legislation of the UK?
My lord, it's the proposition I recapped briefly a couple of moments ago.
Is that in the skeleton at I mean, I'll put it another way, what's the principle of law which is transferable?
Well, my lord, we say the principle of law is transferable, is that drawing the parallel there, intention to demolish or reconstruct simply for the purpose of using the statutory scheme to get the tenant out, has the parallel in this case of saying that occupation solely for the purpose of trying to get yourself into a benefit that's provided for by the statutory scheme.
But I don't
isn't
follow
enough.
this, because this is what happens in the application of legislation all the time. People try to bring themselves within the terms of the statute. Whether they succeed in doing so or not depends upon the true interpretation of the statute, read purposively. Are we going to gain any assistance from this case in the quest for the true interpretation of section 45?
Well, my lord, I will come on to make submissions shortly on this point about intention, because intention is a central question when looking at beneficial occupation or actual occupation. So I will draw a parallel there between the quality of the intention that the Supreme Court found was necessary for the 1954 Act, and what we say that means about the quality of the intention that's required to have a rateable occupation here for this statutory scheme. But as I said,
This is a regime for protecting the security of tenure of business tenants, so they're not winkled out or denied a new tenancy, say on grounds which properly fall within the meaning of Section 30.
Indeed, my lord, and possibly in pulling out these passages, I've strayed slightly into what's more of a ground 1 type argument than a ground 2 type argument, because obviously, as we say in our skeleton at paragraph 79, although we rely on Francis in part for the point about conditionality of intention, which is something I will address in my submissions shortly, we say that Francis does also support the thrust of the case we're making under ground 1, that's another example of the court saying you should not construe the statute, or the statute should not be construed in such a way that essentially enables an individual to take advantage of the setup provided for by the statute contrary to its purposes. So there, you should not be able to generate an intention to demolish or reconstruct if there's no practical use to that at all, and the only reason you're doing it is to get rid of the tenant.
Yeah,
Simply
well,
to get rid of
you've taken us to the third sentence in 17, which might be regarded as a recitation of what's going on rather than the development of the principle. Were you going to take us to the later paragraphs, which I think try to articulate the principle?
Indeed, my lady, forgive me, I had strayed from my text.
Well, that would probably not help by us.
But the next passage I was going to go to is that quite paragraph 17 quite neatly encapsulates, we said, the issue that was at play here. But it's
What about 22? Because that does refer to Ramsay.
indeed, my lord. I was going to go, if I may, start with 18 and 19.
Yeah, please.
Because 18 is where the court goes on to look at the quality of the intention that's needed for the purpose of the 1954 Act. And it's midway down that paragraph, just above E, it's intended to carry them out only conditionally upon they're necessary to get the tenant out, and not, for example, if he left voluntarily or the judge was persuaded that the works could be done by exercising a right of entry. At 19, for the second sentence, picking up what the issue is there, the issue is not mere conditionality, but the nature of the condition. And this is all brought together in my submission, that the key principle we find further down paragraph 19, starting at H. These provisions show that the landlord's intention to demolish or reconstruct the premises must exist independently of the tenant's statutory claim to a new tenancy, so that the tenant's right of occupation under a new lease would serve to obstruct it. The landlord's intention to carry out the works cannot therefore be conditional whether the tenant chooses to assert his claim to persist in the claim. The acid test is whether the landlord would intend to do the same works if the tenant left voluntarily.
That's the principle.
That is the principle that I draw across, my lady, to this case. The acid test is, would Pole intend to go into occupation of these premises, if it wasn't for the statutory scheme? If it wasn't for the possibility of that occupation triggering the procedures, the processes, the entitlement, the potential benefit under regulations 4A and 5, would they do it? And just to finish up at the end of paragraph 19, it's the penultimate sentence. In my judgment, a conditional intention of this kind is not the fixed and settled intention that ground F requires. So it's still making the same point, that it's saying, well, that's not the right intention for the purposes of the Act, in the same way that we would say that an intention to occupy or occupation, which is purely to try and trigger the provisions of Reg 4A and 5 and would not exist absent Reg 4A and 5, cannot be sufficient. And my Lord Justice Holgate asked about where this was in our skeleton. It's really the point covered at 78 of our skeleton.
I beg your pardon?
Paragraph 78 of our skeleton. It's the last two sentences of 78. here Pol intends to occupy only in order to rely on and secure the benefit which flows from engaging the Reg 4A 5A exemption. Absent that benefit, there be no occupation, just as the landlord in Francis would not have intended to do the works, but for section 31F. And we make the point in paragraph 76 of our skeleton about the circularity of that as well, that you're having to rely on the statutory scheme to generate your benefit, but you only get the benefit if you're within the statutory scheme. My Lord Mrs. Holgate also asked about paragraph 22.
They just make it clear that for
They
the
didn't need
reasons
to get
they've
into-
already given, they've no need to go into Ramsay.
Absolutely, my Lord. And so perhaps if I could just,
Well, yes, I mean, maybe it's slightly more nuanced than that, because I would suggest he says he doesn't need to deal with a submission, that you can simply ignore the intention.
yes,
I don't think his lordship thought he was doing anything other than applying a purposive interpretation anyway,
no,
which
indeed,
is what
yes,
Ramsay, as now rationalised, involves.
indeed. It wasn't doing an express Ramsay analysis, perhaps if I could put it in those terms, my lady.
Talking about Ramsay is it's sometimes better to talk about Barclays Mercantile, which was when the Ramsay line of policy was re-explained as purposive construction.
I'm grateful, my lady. So that was, I will touch back on Francis if I may in my submissions shortly, but I hope that's been a bit of an introduction to that case because it does feature prominently in our skeleton. So that brings me to the third part of my submissions, which is the judgment below and the errors that we say it discloses. The ground two, or the ground two arguments are considered by the judge below, starting at paragraph 1112 of the judgment. That's core bundle 6, starting at page 108. But the key passage, if I may, being mindful of time and trying to keep my submissions relatively short, the key passage we say is that at 114, which appears on page 109, which is, and perhaps if I could just pause there. And that is really in our submission that the sort of the core crux of the judge's reasoning on this point. And in short, and as we identify in our skeleton, it's just helpful, it's slightly variously at 5B, 6C and 75 to 79, we say that the court erred in concluding that the land criteria for rateable occupation were satisfied in the circumstances of this case and did so in 4 respects. So those 4 respects are, firstly, in concluding that possession of value to the possessor is present, where the value is the occupation itself. That's the first sentence of 114, agreeing with Mr. Justice Carr's analysis in the Trafford case. That's the planting of the flag for occupation point that Mr. Forstick referred to earlier, and I know you've been taken to that passage, so I won't go to the Trafford case. The second error that we say is disclosed by 114 is that the judge finding it was not necessary to identify a benefit or a purpose beyond that of occupation leading to a potential rates mitigation benefit. Thirdly, that the court erred in concluding that there was sufficient volition or intention to occupy, where any intention to occupy would not have existed in the absence of regulations 4A and 5. And fourthly, that the court erred in finding that there was a benefit or a reward such that arising from Pol's occupation, such that its occupation constituted beneficial occupation for the purpose of Lang 3.
Could you say that again, please?
The court erred in finding that there was a benefit or reward from Pol's occupation, such that its occupation constituted beneficial occupation for the purposes of Lang 3 in circumstances where that benefit or reward was parasitic or upon a benefit potentially accruing to a third party and accruing after the period of Pol's occupation.
That was the point we were discussing with Mr. Fawcett this morning.
Indeed, my lord, and for
Out of the savings, you know.
parasitic upon or derivative
Yeah.
of, it's a different way of making the same point. And if I can address each of those in turn, and in zoom, so I'm conscious that some of this ground was covered by Mr. Fawcett this morning, but so the first point of it, the first error, possession of value is present where the value of the occupation itself. That obviously finds precedent in the Trafford case, as Mr. Fawcett referred to this morning. The key paragraphs are 124, 125 of that case, so I don't propose to go through, I know you were taking them earlier. And essentially, so distilled, we say that really discloses the core error that's been made by the court below here and by Mr. Justice Carr in the Trafford case. That is that occupation for occupation's sake is sufficient to constitute beneficial occupation for the purposes of Lang 3. And that is an erroneous conclusion for three interrelated reasons, or there's three different ways of saying why that's erroneous. Firstly, that conclusion, well, occupation for its own sake is beneficial occupation, conflates two of the Lang criteria, Lang 1 and Lang 3, and it would render Lang 3 redundant. If actual occupation is all you need, why the separate requirement for beneficial occupation?
Sorry, let me
Secondly, and relatedly,
sorry, just
sorry,
hold on. Pearls of wisdom are to be written. Yes.
secondly and relatedly, that conflation is not supported by authority. I would say to the contrary, the clear theme of the case law going back to the 19th century is that beneficial occupation requires something more than simply occupation itself. And if I may perhaps just give you two references, I don't know if it's necessary to turn them up, I'm happy to do so. But the first reference is in the Lambeth-Brockwell Park case, to use a shorthand. That's the Lambeth Parish and London County Council case, which you have at tab 7 of the authorities bundle. And this was about whether or not the London Council was in rateable occupation of Brockwell Park. But just if I could flag, the passages I rely on is at the bottom of page 630, where Lord Holsbury distinguishes occupation from beneficial occupation. It's right at the bottom of the page. The passage in particular is probably of more import generally to.
Oh, that was page.
It's page 600. Sorry, page 41 of the bundle. It's page 630 of the judgment. Forgive me, and it's right at the bottom of the page. Once it's been found, as in this case, that occupation cannot, as a matter of law, be beneficial occupation. That's the end of the question. So it was obviously recognising that there could be occupation, but not beneficial occupation.
This was the case of, say, Brockwell Park, where the local authority undoubtedly was in occupation. But the extent of the public usage was such was to make it impossible for the local authority to derive any benefit from the occupation.
Indeed, I think, my lord, to be fair to Lord Holsbury, I think he does question that he doesn't think anybody's in rateable occupation because of the nature of it. But yes, in principle, if anybody is in occupation, the issue is
follows on from the Putney Bridge
Indeed.
case further up the page, which is about highways.
Indeed, indeed.
So you can actually occupy without necessarily
being in beneficial occupation.
benefiting from it.
Indeed, my lord. And if I could just pause there, because I know that there's a point raised in my learned friend's skeleton about it cannot be beneficial occupation where you're prohibited by law from beneficially occupying or taking a benefit. That may be one factor, that might be one reason why you're not in beneficial occupation, but it's not the touchstone, i.e. it's not authority for the converse proposition, we'd say. But the second authority
In
just
other
on,
words, prohibition on financial benefit is not sufficient.
it's
Is not the only thing that.
yes,
stops-
it's not that
it's
as long as you're
the
not
only thing.
yes, if you are prohibited by law from beneficially taking a benefit from the land, that cannot be beneficial occupation. That's the finding in Brockwell Park. We say it's not authority for the converse proposition that provided not precluded by law, of course you're automatically into beneficial occupation and Lang 3 is satisfied. And the second case, just to refer to, just to make good the point, is the Winstanley case, which is at tab 9. And this was about whether or not I'm going to say vicar, it may have been a rector or possibly a parson, but a gentleman of the cloth was in beneficial occupation of a burial ground where he could receive fees for burial. But it's just to highlight that at page 63 of the bundle, page 12 of the report, last paragraph, the Lord Atkinson identifies 3 questions. Does the applicant occupy the cemetery which is rated? If he does, is his occupation a beneficial one, that's a thing of value, and then 3, what's the measure of the value? So again, just that point that this concept that you can't equate actual and beneficial has long-standing roots going back into the case law. And then thirdly, just finally under this first point, and it's recapping on the point that Mr. Fosdick made earlier, that there's obviously nothing in the historical authorities or the cases, certainly prior to the RMS cases that we've been dealing with, that suggest that actual occupation or occupation for its own sake is enough. And that's obviously unsurprising given the history that Mr. Fosdick's been through. So essentially we would say in summary under this ground, just to put it together in the context of the Lang ground of appeal, that to suggest that benefit or value for the purpose of beneficial occupation is satisfied by the benefit or value being the occupation is circular and meaningless. And so that's the first basis on which we say the court materially fell into error. The second respect in which we say the court erred was in finding it wasn't necessary to identify a benefit or a purpose beyond that of occupation leading to rates mitigation. And just to highlight here that I think Ms. Fosdick identified earlier, this isn't just this judgment, it's Trafford, but it's also, there's also a theme of this in the PE, Public Health England case.
Sorry, well, I'm a bit lost by your numbering. So this is one of the errors of the judge.
This is the second error. This is the second
yeah.
error that we say the judge made, that it wasn't necessary to identify a benefit
Yes.
other than occupation to leading to rates mitigation. And I was just highlighting that here we do not shy away from the fact that this isn't just the case below in Trafford, but it also picks up on what was said in Public Health England at paragraph 64. Now, in terms of beneficial occupation, I would not usually go to a commentary rather than an authority, but in this instance it is helpful perhaps to start at ride-on rating, which we have right at the back of the authorities bundle at tab 35, just because that does helpfully draw together a lot of the historic case law into quite a neat proposition. And this is starts at page 589 of the authorities bundle behind tab 35. And it's under the heading D, beneficial occupation, paragraph 182, identifying this issue that you don't need to have pecuniary profit. But the passage I rely on is about 5 lines up from the bottom, which starts, these cases show clearly that beneficial occupation does not connote pecuniary profit, but in order to create liability to rates, beneficial occupation is necessary if by that term we mean an occupation which serves a purpose. And the same appears in the last sentence of the passage of 183 on page 590. Well, that might be helpful, obviously, what's meant by serves a purpose. And there's some assistance can be found in the case of Wimborne District Council and Brain Construction Company Limited from 1985, which you have at tab 17 of the authorities bundle, starting at page 208. And if I just may very, very quickly provide a quick trace of the case, unless, my lady, you're intimately familiar with the fish
Yes,
farm
listening.
case.
So tab,
It's tab 17. And essentially this was a case about a parcel of land that was adjacent to an existing fish farm. The owners of the fish farm wanted to excavate some lakes and ponds to extend their fish farm. They employed some contractors to do that and the landscaping. The contractors employed some subcontractors who basically had an arrangement whereby they'd dig the ponds and the lakes, they'd extract the gravel from it, and I think they had to pay like £1 a tonne or something to the contractors. There was kind of a quid pro quo in terms of doing the work, and in return for that there was a winning of the gravel. And the issue in that case was whether the subcontractors were in rateable occupation of the land. And it seemed and if they were, there was an issue about actual occupation and exclusive occupation, but it seems things got a little bit muddled because people started talking about purposes and primary purposes and secondary purposes, which is why I've come to this case. So the court did have to look at what was meant by purpose in the context of rateable occupation. And we find this in the judgment of Lord Justice Lloyd Jones on page 239 of the report. It's 213 of the authorities bundle. And it's the first full paragraph starting, moreover, one has to be wary in this context, as in almost every case, the word purpose. And the key points I will pull out if I may is that it's the second sentence. Here the Crown Court was using it in what I believe was the correct sense, namely the object of the activity in question rather than the motive behind the activity. Counsel for the Rating Authority put it epigrammatically when he said that purpose in this context means what a man does rather than why he does it. And then jumping on a sentence, the making of a profit, making of a profit out of the resale of the gravel was undoubtedly the motive, as it would be with any contract on a building site, but it was not the purpose. Now, what I distill from that, my lords, my lady, is that distinction. The purpose is what is the person doing, rather than the why. What is the reason why they are doing it, or the motive? And it's my lord, I think it's fair to say, just as a quick segue, I think the similar analysis was arrived at by my Lord Justice Holgate in the Robinson Webster case at paragraph 64. Sure it wasn't, my lord. Would never suggest such a thing. But there's a similar analysis, that idea of what's the objective effect or intent as opposed to what's the subjective reasoning for something. And my lord, my lady, the submission that we make on this ground is that in deciding that there is beneficial occupation, where the benefit is solely a share of a business rates exemption saving that may be realised in the future, the courts have failed to recognise the distinction between the object that you need for the purpose of beneficial occupation and the motive, which might be the why you're doing it, but isn't the purpose in the rating context. And in terms of the lack of clarity which there has been, or the confusion there's been of these points, that is quite clearly seen in, for example, the Trafford case at paragraphs 125 and 126, which is in tab 24 of the authorities bundle. And the page it's at 343 of the authorities bundle.
What are you saying here? Are you saying that the courts below have failed to have elided motive and purpose?
Yes, my lady. So it's clear that when you're looking at rateable occupation, purpose is the what. It's the object of the occupation. What are you doing on the land? And there's the why might you be doing it, which is the subjective intention. It's the reason. It's the motive.
Right,
Which
I mean,
is
just to take an example, we presumably wouldn't be here if the letting had been of, say, a pop-up shop at a knockdown rate,
No, Melanie, because there'd be a what? There'd be the occupation.
Because you would say, well, there's real occupation.
Well, there's occupation for the use of the shop. That's the
use of
purpose
the
of
shop,
the business.
even if it standing right back, that's not the ideal sort of tenant or rent or whatever.
The reason why the landlord or the tenant may have entered into the arrangements may have been partly motivated by it works out for everybody because the tenant gets a cheap pop-up shop and the landlord then has got somebody to take property off his hands for a bit or something like that. But that's the why. But you can see a concrete what, you can see an obvious
Well, I was thinking
tangible
that's
value.
an example where the
Yes.
motive might well be something.
Yes, but there is a value that exists. There is a what, a purpose, an object that exists independently of any sort of eye to business rates purposes.
Well, you brought in the word I was thinking of, value,
Yes,
which is sometimes used as a synonym for benefit.
indeed, my lord.
Because going back, we don't need to go back to RIDE, but that section you were reading to us was about the proposition you don't need to have a pecuniary profit.
Indeed.
And the classic case law, which it cites in footnote 7, LCC and Erith, is all about a local authority which has to provide a sewerage
Yes.
system. It's under, in other words, it was a benefit to LCC that it discharged its statutory duty.
Indeed.
No scope for making money. And even before that, we had cases about schools being provided by education authorities.
Indeed.
No money being made, but it was of benefit because it had that purpose. And sometimes there isn't a sharp distinction between purpose and motive, perhaps.
Indeed, my lord. But in this
Motive
case,
perhaps is not the test, but it can shed light on whether there's a relevant purpose.
indeed, my lord. Yes, and that at risk of segueing back to the Francis case, that was one of the things that was looked at there. That when you look at things like the objective value, the objective benefit, or any utility to the works that are supposed to be carried out, that might shed some light on whether there is a genuine intention to do this for a reason other than just trying to sort of get yourself within section 31F. But my lord, I do draw that distinction because I do say that the courts, my submission, the courts have elided those two by saying, well, the benefit here is, well, they're occupying for the purposes of rates mitigation. Well, that's motive. That's the why are you doing it? Look at the what. The what can only be occupation. And on the agreed facts that there are in this case, in the case summary, it's accepted that the only benefit that there is from the occupation is the rates mitigation. That's the why.
Well, you're saying you can I think you're saying you can effectively disregard the boxes because of the agreed
Yes.
fact
Yes, my lady.
that, contrary to what is said in the blurb in the supplemental bundle, they don't have value.
Indeed, there's no claimed benefit or value of the occupation separately from that occupation generating a rates mitigation. And in my submission, when you're looking at the Trafford case, forgive me, I think it was I was at 125. It's the second sentence of that. I find no concept within the meaning of the word occupy requiring a purpose, motive, or motive beyond that of occupation itself. And at 126 over the page, they talk about the billing authority erring because they thought they could lay these informations because there was no purpose other than rates mitigation. And you see similar language in the PHE case.
Basically, what you're saying is occupation itself is another way of saying actual occupation.
Yes. And to the extent that there is a benefit in this case, it can only be the rates mitigation, which we say is on the motive side of the line. It's not on the object or the purpose side of the line. And that so where the courts have found there to be some value linked to the rates mitigation, they have erroneously conflated those two concepts and themselves fallen into error. Because they've relied on the motive to provide the benefit, not the occupation to provide the benefit. And I've probably now traversed my point, but just to finish up on this, is that there is a point raised in my learned friend Skeleton at paragraph 115, which is behind tab 3, page 64. But perhaps I can just, I'm sure my learned friends will come to it in due course in this. But they essentially say that the City of London's erred because what we're doing is focusing on the motive. We would say, well, with respect, actually, that's the error the courts have made. We're not trying to sort of look at motive and say motive is the reason for driving this. What we're saying is actually the error that's come is in the courts below and in the earlier authorities by, to the extent it finds a benefit or a value, deriving that from the motive, the why, not from the occupation, the what. And I think just finishing up on this point, if I may, I've talked about it in terms of purpose. I'm conscious also of the language that's used, for example, in Lang, is the concept of occupying for the purpose of the occupier's business. But in my submission, that's a distinction without a difference. Talk about what's the purpose. Are they in occupation for the purpose of their business? Because that language appears in the judgment of Lord Justice Jenkins in the Lang case, which you have at tab 11, and the relevant passage is at page 90 of the authorities bundle, 357 of the report. And it's the last paragraph, and it's about a third way up. It starts thirdly. It is said that. Sorry, forgive me. It was Mr. Justice Jenkins. I've misread that. It said thirdly. It said the possession must be of some use or value or benefit to the possessor. That's the language of value that my Lord Justice Holgate mentioned. But as to that, it seems to be enough to say the contractors occupy those premises for the purposes of their business. But what I draw attention to, and it seems to me quite immaterial, that their business in this connection consisted of the carrying out of for reward of a particular construction profit. The same distinctions being drawn there. They were an occupation, they had huts, they were extracting materials. There was a what. The fact that they might have been doing it to get a reward under a particular contract was the why. That's not what's driving it. So by way of summary, if I may, in finding occupation is benefit or value, in these cases the courts have failed to recognise or correctly apply the distinction between object and motive, and in concluding that there's beneficial underlying 3, where there's no benefit or value which accrues to POL other than if the RMS is successful and there's some rate saving down the line, because that requires looking to the motive, not the object of the occupation. That probably takes me to my third point, third respect in which we say the court erred in J114. And that is that there was sufficient volition or intention to occupy where it wouldn't have existed in the absence of regulations 4A and 5 of the 2008 regulations. As I indicated in response to a question from my Lord Justice Holgate, intention is a central concept that comes up in the context of rateable occupation. That appears, for example, in the Melledew case. It helps me just to give a reference. It's Authorities Bundle 8, tab 8, pages 52 to 53. And the theme of intention is one that crops up through the macro, the PHE, the traffic cases. And my submissions on this ground really come back to the Francis case. In the Francis case, it was found there wasn't the right sort of intention or the right quality of intention, where the only base of that intention was to try and get within 31F of the Landlord Intent Act 1954, i.e. the intention to do the works would not have existed but for looking to the statutory provisions. And in the same way, we say in this case that any intentional volition to occupy does not exist, would not exist in the absence of regulations 4A and 5. And so just as in the Francis case, where it was found that that reliance or that need to rely on the statutory provision in order to found intention wasn't enough to bring you into the statutory scheme. So we say here an intention that is dependent upon the operation of the statutory scheme can't be enough to bring you into the statutory
Is
scheme.
intention ordinarily an ingredient for rateable occupation? Does it appear in Lang, for example?
It doesn't appear in Lang in that sense, my lord, and I apologise if I've overstated it. It's what I was particularly picking up on was Melledew, which is at
Exactly,
tab.
and you also get in this rather peculiar decision the word volition,
Yes.
which I think is focused on by the other side, and I've managed to spend many happy hours dealing with rating cases without encountering volition before. But isn't that a rather special case, Melody? It's an empty warehouse,
It is, my lord.
and it's kept ready, as the judge is explaining that case, so it can be used as a warehouse as and when demand requires. Maybe that explains why they used the word intend.
I think, yeah, I mean, the problem with intention is that you end up with up into the purpose and motive debate.
Yes.
And I just wonder if intention helps explain some special cases.
Yeah, that's
like validity.
yes, absolutely. That's part of the problem with rating. It has so many special cases, and there's a danger of extracting general principles.
My lord, perhaps the reason I've picked up on that particular point is something that's stressed in my learned friend skeleton, but it also appears, for example, in macro. So that probably might have been the better authority for me to give you. It's at paragraph 43 of macro, which is behind authorities bundle tab 20, page 265.
265.
265.
I mean, yeah, they had Judge Jarman had Melody cited.
Yes. Indeed.
I'm not sure it really helps, that sort of thing helps here, because in one sense, melody and other cases where intention has been referred to is all about what may or may not, in a sense, what may or may not happen in the future. We haven't got that here.
I mean, part of the problem with cases like Melody is that you've got the, dare I say it, the rebus extantibus principle. You take the property as it is, not as it may become, I think the old 18th century cases say. And the judges are getting around that, but they don't worry about that. Look at the intention. This is how they intended to be used, so it's ready for usage by clients when they come along with their goods. But I mean, in some ways, you seem to be using intention as a relevant ingredient because it makes a link with Francis.
My lord, I think the reason we picked up on the intention is because
my lady says you may not need intention.
My lord, my primary submissions are the ones I've made so far under the circularity of actual beneficial and the purpose motive. Perhaps I should have pitched point 3 as to the extent that intention is considered to be relevant and is relied on in a number of the RMS cases or appears in a number of the RMS cases, we say it doesn't actually help in the other side in any event. That may have been a more correct way of putting it. I've mentioned 43 of macro where it appears. It also appears in 66 of Public Health England, tab 28, page 422.
It'd be interesting to know whether it appears in mainstream rating law. My memory may be weak, but I just can't remember it popping up that much.
No, my lord, I will take it briefly then just say to the extent, perhaps I just say then to the extent that intention or volition to occupy is something that gets brought into the mix, we would respectfully submit that this is a Francis type scenario and you can't rely on trying to get into that you can't have the requisite quality where you wouldn't have the intention but for the statutory scheme.
Francis point.
Yes, thank you. And my lord, just if I could do a final point on this, because I'm trying to pick up points from the skeleton as I go through, and my learned friend's skeleton refers to this at paragraphs 124 to 125, which is page 66 of core bundle tab 3. But if I can just make the submission briefly in passing, that seems to proceed on a misunderstanding of what we say, the conditionality, the relevance of the conditionality in Francis. It's not a timing point. It's not about at what point had the landlord or whole formed the intention of doing something. It's about the quality of the intention. Why did they form the intention of doing it? Would they have intended to occupy the property? Would there have been volition to occupy the property if that's the relevant part of the test, but for the statutory scheme? And we say short answer, no, because nobody in the real world would take a lease of a property with business rates liability for the sake purely of occupation. And that also responds to the hypothetical that's posed at paragraph 119 of the judgment, which I think Mr. Falk referred to briefly in passing, which is where the judge said, well, wouldn't this have been occupation in 1966? Well, no, because it wouldn't have happened in 1966 because you wouldn't have had anybody going, I'm going to go into a property for the sake of going to occupation just for the sake of occupation, generating, a liability to business rates. So that's probably a shortened version of my ground three. And then just finally on this section about the errors and what we say were the errors in the judgment, the fourth respect, in respect of which we say the court erred. And this, again, this has been traversed this morning, so I'll take it very briefly. We say the court erred in finding that there was a benefit or the reward from Paul's occupation, where there was nothing that came directly from Paul's occupation itself. Any benefit or reward was a derivative of a benefit potentially enjoyed by their landlord after their occupation had ended. And on that's 4 brief points. The first was there's no benefit to Pole arising directly out of the occupation of its premises, and you look in vain in the authorities, apart from the RMS authorities, for finding a situation like that. It's not like Wimborne, it's not like Winstanley. Secondly, and relatedly, it's not an independent benefit arising to Pole from the occupation, it's the parasitic derivative point. And again, the other cases don't seem to be about, well, you might get a benefit if somebody else gets a benefit and you get a bit of it. All of the cases have looked at the value or benefit directly to the occupier. Thirdly, we say the benefit is conditional in any event. It's dependent on whether the RMS is actually effective to trigger the statutory scheme. If it's not, Pole has to pay all the money back. And that is the terms and conditions that Mr. Fawcett went to earlier. And it's also dependent on what the landlord may choose to do in terms of letting the property. If they do have it vacant for the whole 3 months, or if they find a tenant in the interim. And fourthly, as in Francis, and that's the passage I referred to very early on in the Francis case, paragraph 17, that the value or benefit here is wholly dependent on or realised only through the operation of the statutory scheme. There's no freestanding benefit but for the statutory scheme. My Lord, I'm conscious there's probably a few points of detail in the respondent's skeleton or the judgment that I've not necessarily dealt with, but I think I've traversed certainly the substance of the case against us. So unless there's anything I can particularly assist with, those are my
Thank you very
submissions.
much, Ms. Lee. Very grateful to Mr. Kalinsky.
My lords and lady, the route I propose to take is to start with what I hope is a helpful encapsulation of the shape of the case that I advance on behalf of Pole, then to deal very briefly with the facts, to say a few words about that, then spend some time on the statutory scheme, both the current statutory scheme and some of the history, and then I'll start with Rossendale in terms of, then I will make some points about the law, about the approach to rateable occupation. Then I propose to deal with Rossendale, but then to go back to Barclays, and I do that for the reason that my Lady Justice Falk indicated, that is the intellectual foundation and the restating of Ramsay that was applied in Rossendale. And I just, as an important signpost on that, I take issue with my learned friend's formulation that Hurstwood and the Ramsay principle is simply about giving effect to the purpose. No, it's not. It's doing that in a particular way, and the particular way is construing the statutory conditions in the light of their purpose, but it is an exercise in construing whether we are within or without the concepts as they are used by the legislator.
And the language used by them.
Exactly, and my submission is that is very important in the present case in a way that wasn't at issue in Rossendale, and my learned friend's whole case hitches its wagon onto Rossendale without recognising a couple of important limitations about Rossendale. Not a case at all about occupation, and as I'll show the court, not a case in which the Supreme Court was actually assisted with submissions from counsel as to the statutory purpose. It's no part of my case to say they got anything wrong, but it is very much part of my case to say there's much more to say to understand these provisions, and you won't find the answer to any of that in Rossendale. Rossendale then back to Barclays, and then a few words on the subsequent case law. We've got the Emerald Shore case of this court and my lord and my lady, part of the Constitution. I'll simply say that's a straightforward application of a Rossendale case.
You get it right.
I'm certainly not going to submit to the contrary, my lords.
Joking apart, I think there is actually an outstanding application.
Yeah, but my lord, my answer to that is it follows inexorably from Rossendale, because it's precisely the same issue and it's exactly that. But actually, the divisional court of my lord and Mr. Justice Mould actually is looking at Rossendale in a slightly different way and making some important points that are much more aligned with the observation that actually you need to think about how Rossendale applies with the statutory tram lines in focus, and also thinking about what precisely is intended. And it also helps on the issue of purpose and motive, which we'll come back to. And then I will respond to the billing authority's case, and my learned friend, Mr. Wilcox, will follow on Francis. We've divided things up slightly differently to my learned friends, but Mr. Wilcox will follow on Francis, and if there's any spillover on rateable occupation, he may also mop that up. But we're anticipating his submission to be relatively short. So may I then start with the encapsulation? I say at the outset, I understand that some of these propositions will need testing, and that the court might be inclined against some of them. But this is the way, on behalf of Paul, I do invite the court to think about the shape of the case. So firstly, before Rossendale, intermittent occupation arrangements were assessed against the established law of rateable occupation. Secondly, Rossendale, properly understood, requires a discovery of the legislative intention. Thirdly,
Mr. Kalinski, same point as I made from time to time to Mr. Forsdick.
Yes.
If you're doing numbered paragraphs, and numbered heads a point, you want us to write them down.
Yes.
Very happy to, but you need to go a bit more slowly. So point number 2, Rossendale.
Properly understood,
Yes.
requires the discovery of the legislative intention.
Yes. Yes.
Thirdly, the relevant legislative intention is to prescribe a minimum period of occupation for resetting the periods in respect of which no unoccupied rates arise under the scheme. Fourthly, occupation has a settled meaning and is used consistently throughout the statutory scheme. And I shall be submitting that the Deputy Judge was right to recognise that Pole's occupation is within the ambit of that settled meaning. Fifth, the Secretary of State is responsible for prescribing the circumstances in which hereditaments are subject to unoccupied rates. He could alter the operation of the reset period or make other changes. and he has been and continues to be active in his consideration of what changes to make. Sixth, so far, the Secretary of State has not prescribed a different concept of occupation for the purpose of the reset provisions. Or made other fundamental alterations to how they operate. The absence of such a reform might reflect the fact, recognised by Mr. Justice Norris in the PAG case, that the underlying socio-economic policy choices here are not necessarily straightforward. And part of the reason I say that is because there is a disparity between the economic conditions in which the 2007 and 2008 reforms to empty rates were conceived and those in which they were implemented. And so seventh and finally, Ramsay cannot be used to force that policy choice by judicial interpretation. That's because it's concerned with identifying the legislative intention as expressed in the statutory conditions. Not reformulating those statutory conditions for liability.
You can say that again, please.
The last one.
Sorry, I
So,
was
yeah.
doing quite well.
No, I'm sorry. So Ramsay cannot be used to force that policy choice by judicial interpretation. The doctrine is concerned with identifying legislative intention as expressed in the statutory conditions, not reformulating the statutory conditions for liability.
That's back to the language point.
Yes, yes. So that's the shape of what I say. I appreciate there's going to be some points there that the court will want to robustly test, but I hope it's helpful to give that indication of the overall scheme of the argument. On the facts, my learned friend Mr. Forsdick has covered them fairly. We're proceeding on the basis that all of the material facts are agreed. I accept, and my client's been very transparent about it, that its business is organising intermittent occupations. And that service, which is how it describes it, is attractive to property owners, including, on the evidence in some instances, public bodies, including central government, because it's structured around the statutory rules for resetting unoccupied rates liability. Oh, sorry, for resetting the non-imposition of unoccupied rates liability. Subject to the arguments in this court as to its legal effectiveness, Poll's arrangements follow the framework within the legislation, going into occupation and out of occupation after the 6 weeks, enabling the property owner to benefit from fresh periods of no liability. In terms of the terms and conditions, which are at page 146 of the core bundle, you've been taken to most of these. I just want to draw attention to a couple of provisions. So in the terms of conditions at page 146, this is an upfront scheme in terms of what's happening. It's transparent, and at 146, paragraph 3.2, it makes it clear that we will provide you with a lease for our tenancy of your empty commercial property. This is a legal and binding document. The lease will be signed by by you and us in order to be complete. Under no circumstances will we backdate the lease with you. Once the lease has been signed on behalf of both you and us, our service will commence. Date of occupation will reflect the lease. So the scheme is to operate in accordance with the lease and with the statutory periods, and within the lease, my learned friend took you to most of the clauses, but I did want to draw attention to page 143. There is a covenant of quiet enjoyment, and it's not a qualified one in the way that, as I recall, the court commented in Emerald Shore about that. This is a conventional covenant of quiet enjoyment, clause 6.1. And my learned friend's argument fairly proceeds, as is clear from paragraph 10 of his skeleton, on the basis that the leases are genuine and conferred a right of exclusive possession on Pole. And then the chronology, which my learned friend flagged up to you, shows that they go in and out on 6-week intervals to try to give effect to the statutory tramlines for resetting the period for which unoccupied rates are due.
Well, it's a genuine lease, and they have rights of lessee, but as I understand the break clause and the notice to vacate clause at the end, they can be asked, please leave at the end of the week, and they will.
That's the final clause that the early vacation clause that my lord is referring to. That is page 144.
Yeah.
Yes, well that is one of the clauses. This is not a case where that has been exercised and we've got express concession about the effect of the lease, but that is, I accept, part and parcel of the terms. Although I think my
So you say not being exercised, but 8.7 was exercised by the
yes, but the
date of the lease.
no, that's correct, my lady. I was answering in relation to 8.8.
Yes.
8.8 hasn't been exercised, as in the request to leave within 5 days for early vacation, as I understand
Just
it.
wondering why it's in there,
Yeah,
because
it's not very
you've got a lease which ostensibly lease for 6 months, but it's always granted simultaneously with the break clause saying this is going to last for 45 days. Is it possible that within the 45 days the landlord will find an occupation tenant? And in those circumstances, the parties have agreed that the tenant found by the landlord is going to be there 3, 5, 10-year lease can go in, but they want at least 5 days to get their valuable boxes out.
So the answer as to where the rights are in terms of that is that I don't differ from the answer I think my learned friend Mr. Forsdick gave to the court, which is you would construe that compatible with the requirement of the break clause, but in the eventuality that you are putting to be, there would be a question of how you construe this lease as between those potentially two provisions which seem to be somewhat at odds with each other.
But are they? I mean, surely the common sense answer is, as my lord says, landlord suddenly got a tenant that wants rapid occupation, is prepared to pay good money for substantially taking over the property. Cole can be asked to leave on a few days' notice, and it would be contrary to their business model to say, nope, we're here for 45 days.
That may be.
Got to pay the rates for 45 days.
Yeah.
Well, no, that may be. That's not this case, but that is on the face of it one reading of this agreement. And I don't want to say anything more, but I do point out in our skeleton that there does seem to be a mismatch between. It wasn't particularly pursued orally, but the point in paragraph 11 of my learned friend's skeleton, which seems to be saying doesn't accept that the first respondent. Let me just get that in front of me whilst I make my submission. if necessary, my learned friend submits that it doesn't appreciably impact on the second, the first respondent's beneficial interest. So I don't understand that, because that's a submission that says we will, if necessary, argue that 48 Street Holdings are the person entitled to possession.
I haven't heard that pursued
No.
really, and there is a question about the grounds of appeal when you look at that scope of the grounds of appeal.
Yes, so
It was confirmed to us that the lease is not being, there's no attempt to look behind the lease, so
no, so I'll leave
for
that there.
myself, I wasn't concentrating on paragraph 11.
So I don't need to trouble you with submissions on that, but that's inconsistent with the premise of much of the rest of the argument, and it's also inconsistent with the billing arrangements, which has been to bill Pole rather than 48 Street Holdings in relation to that period. So may I then just go to briefly, just to jump off into the issues from the supplementary bundle has the agreed case summary at the start of it, and may I just ask the court to go to paragraph 11, which frames the critical issue in this way, and I just want to pause over this as a way of identifying some of the issues. So paragraph 11 on page 5 talks about, well, is the rates mitigation scheme effective in generating a 3 months of occupation of exemption from empty rates, and then it says that will turn on a purposive construction of the legislation, on whether on a purposive construction of the legislation the placing of boxes and their contents in the premises for 6 weeks mean that the premises are occupied within the meaning of Reg 5 of the relevant regulations for that 6-week period, thus avoiding Regulation 5 and triggering a fresh 3-month period of exemption. Now, that is, with respect to a helpful framing of the issue in this way. It focuses on what is done rather than why it is done, and that is consistent with the difference between purpose and motive. So Pole's purpose is the placing of boxes as an overt act of occupation done for the purpose of its business. Its motive is to get some financial benefit from doing so. But those are two distinct things, and the way that issue is framed is, I would respectfully submit, sensitively drawn up with that distinction in mind. It's what Pole does that forms to be evaluated, not why it does it. And I'm going to come on to that, both in the standpoint of rateable occupation and for the purpose of the Ramsay arguments. But it's also clear that so whether the placing of the boxes within the unit as an overt act of occupation throughout the 6-week period pursuant to the right to occupy conferred under the lease amounts to occupation for both the purposes of section 43 of the Act and for the purpose of the Regulation 5 reset period. It being common ground, as I understand it, that the concept of occupation is common to both of those statutory limbs. And I observe, and I'll come into this in more detail, that is a different question from what the court addressed in Rossendale. Rossendale was about unoccupied property and whether it stayed exempt or not. It wasn't about the boundary and interaction between occupied and unoccupied liability. It didn't involve any disregarding of any physical acts. And I say that this does. I appreciate that that's a contentious statement, but I think just for understanding what Rossendale does and doesn't establish, there's nothing in Rossendale that involves any disregard of any physical act. And there's also nothing in Rossendale, and again, this is probably a contentious framing, but there's nothing in Rossendale that supports the levying of rates on a counterfactual basis. And we do, I submit, need to have a discussion about rates not being counterfactual absent a positive indication to the contrary. And I'll come on to that when I talk about the statutory scheme in just a moment. And also the concept of occupation, which was a statutory concept, section 65(1, had a singular function in the statutory scheme in Rossendale. Here we've got an odd situation because we've got a statutory definition of occupation in section 65(2, and then we've got a prescription of a reset period that's completely within the gift of the Secretary of State as to what that should say, but it chooses to use the same concept of occupation, and everybody agrees that occupation means the same thing under both elements of that. That's a totally different dynamic in terms of the holistic, making holistic sense of the statutory scheme than confronted the Supreme Court in Rossendale. So I'll come then to the statutory scheme, if I may, and I want to start with the 1988 Act. I fully appreciate it's relevant to look at where the 1988 Act came from, but you can't do that at the expense of construing the actual current legislation. So just for example, one of my learned friends' arguments was this idea that it would be ultra vires he didn't use ultra vires, he said contrary to the purpose, for certain elements of prescription to be made that would be contrary to what he said was the underlying purpose of the statutory scheme. Now, if we unpack that for a moment, there's a Ramsay fault in that at the beginning because he's equating the pursuit of the underlying purpose with the Ramsay exercise. But we know it's a completely different exercise to that. It's understanding the statutory conditions in the light of the purpose. So when we look at the statute as we've got it, we'll find that
the purpose is given by the language of the statute.
Yes.
It's not something out there which is separate from the language of the statute.
Exactly. It's not an overriding consideration that has statutory force. It is a means for understanding what the statutory conditions mean. And it's an important part of that, but that's a means to an end, not an end. There isn't a general anti-avoidance rule. There isn't a general purposes trump provisions rule. There is, as my lord said, if you like, an integrated exercise in arriving at a proper understanding of what the statutory conditions mean, informed by the purpose as a means to an end, namely construing the language. So if I go to one of my learned friend's points in his argument, which was that the Secretary of State couldn't prescribe conditions that would defeat the purpose, I think my Lord Justice Bean asked, well, which provision are you relating that to? And the answer really was he was relating that to section 21 of the 1966 Act and provisions of the 1967 Act. But the correct statutory question for this court is, are there limits to what the Secretary of State can do under section 45 subsection 9, which basically says, as we'll see, the Secretary of State can do as he sees fit. So there isn't a purposive limitation in that statutory scheme. There is an extremely broad power on the shoulders of the Secretary of State. Now, none of the Ramsay cases that are relied on in the bundle or form part of my learned friend's skeleton argument or anything like that. It's a completely different shape of a statutory provision that we've got to construe. It's Parliament giving the power to decide how unoccupied rates mean to the Secretary of State in terms that are not qualified, and that's the provision that I say the court needs to construe. And yes, it has to look at the history, but it can't, if I can borrow language from Ramsay, look at the history with the blinkers on and ignore the fact that there's a seismic change in the location of power in the statute going from primary legislation to secondary legislation. Then there's also been, on my learned friend's corrected analysis of the way that industrial heredicaments have moved, there's been a significant change since this was conceived to how industrial properties are used. Firstly, they were not excluded, but it was within the local authorities' ability to do that. Then it was
So the local
centralised.
authority could cut down the ambit of relevant hereditaments
Yes.
in the 66 Act.
Yeah, but what happened in
When they
1980?
passed their resolution.
Yes, they could. And in 1988, there was a change, and there was actually, as the court may, I don't know if the court are aware of this, but all members of the court are aware of this, but the 1988 Act is the parent statute of non-domestic rates. But the other part of that was a change to domestic rates called the community charge, which was quickly rowed back on. So there was a policy shift going on then, and that shift was a shift of centralisation, taking the power away from local authorities and giving it to the central body of the Secretary of State. And what happened with unoccupied rates was consistent with that for present purposes. The power shifted from a permissive regime where the authority made localised decisions to a prescribed regime where it was centralised, but the Secretary of State had the gift to tinker with the precise prescription arrangements. That is a change in the machinery of the statute. So one cannot build a seamless journey back from 1966 to 1967 under the heading of Ramsay without recognising that the relevant statutory language has been transformed. And there's nothing in Rossendale that would suggest you do that, because Rossendale was construing a primary legislative provision, section 65(1).
Why do you say that primary legislative language has been transformed? Transformed in some respects, notably for domestic rates and the removal of discretion about non-domestic rates. Why is that transformative from the point of view of the interpretative exercise to be done here?
Well, if I can answer it in this way, I say there is a process of transformation that's ended up with the 1988 Act, which is what this court has to construe. I accept the history as relevant. The submissions made to you by my learned friend borrow from Rossendale, and as I've said, Rossendale's a slightly different situation because it's construing only on unoccupied rates. It doesn't involve the interaction between occupied and non-occupied, and it's relevant in terms of the history to notice that things have changed, and if I could just identify three big things that have changed. So the location of the power has changed. It's now centralised and entirely within the Secretary of State's gift. The approach to class of properties has changed. Let me give you two examples of that. When it first started, actually, as you may recall from the 1966, it was one of the issues that was exercised in Parliament was empty houses. Well, houses are now completely outside of domestic rates, and also industrial has moved around. And just to set that, Mr. Forsett mentioned this immediately after lunch, but what happened on industrial was it was originally within the ambit of what a local authority could do by resolution. We don't know whether they did or not. Then in the first set of regulations under the 1988 Act, that they were effectively outside the reach of unoccupied rates. And then in 2008, they came within the reach of unoccupied rates, but with a longer initial grace period of 6 months rather than 3. So the policy has not been static in that period. It has altered and responded to the situations that have been changing. That's why I make the point.
Can I just see if I'm keeping up? Under the 66 and 67 legislation,
Yeah.
As I recollect, the Secretary of State had power to prescribe additional exemptions. Seeing some encouraging nods. So the situation before we get to the 1988 Act was the exemptions were either something conferred by Parliament through the primary legislation, or else the Secretary of State could prescribe additional exemptions. What's happened when we moved to the 1988 Act is that all the exemptions are dealt with by prescription.
Yes.
If we're looking for where there's been a shift in power between local and central government, it's a different shift altogether. It's from discretion to pass a resolution at local level to adopt the scheme for unoccupied rates to a mandatory requirement that it exists throughout the country. I think I'm keeping up so far.
Yeah, I'm not. If I may take issue with that last proposition, but
Well, we may need to come back to
Yeah.
that. But if we're looking at the purpose of having unoccupied rates at all, is it not the purpose summarised neatly in paragraph 25 of Rossendale?
I think I'm going to say a qualified yes to that, but let me just.
I'm on the right track then.
Well, yeah, yes, but it does. In my respectful submission, it does. We do require quite careful attention of the
Qualification.
88
Yeah.
statutory scheme and the differences.
Yeah.
So the underlying
The reason why we have rating on our unoccupied properties is to encourage it to be brought back into use and not left vacant
Yes.
for whatever reason.
Yes.
And that's done by a financial disincentive, namely the imposition of a rate.
Yeah, and I don't take issue at all with the underlying purpose being to incentivise property being put back into use. What I say about that is the way that's done is to build the reset period by reference to the concept of occupation, and so therefore on a proper understanding of law of occupation as it's always been understood, my submission is that what my client is doing by using that property for 6 weeks is taking property and putting it back into use under the relevant statutory conditions.
For the 6 weeks.
Yes.
Is that the sort of community use which the Supreme Court had in mind in Rossendale?
Well, I'm not sure. Well, they quoted they first of all, I go back to what I said. They weren't looking. So when we get to Rossendale, they didn't have any assistance from council. They didn't look at occupation at all, and they didn't mention Regulation 5. So we can't find the answer to what the relevant statutory purpose of Regulation 5 is.
No, I understand
in the
that,
Supreme
but,
Court.
my question was framed more broadly, namely the purpose of having an unoccupied property rate in the first place.
So my answer to that, my lord, is that you certainly could formulate statutory conditions that were much more based on the concept of benefit to the community. That is not what they did. They formulated it by reference to the law of occupation. When we go into the law of occupation, what we'll see is that judges have always been incredibly wary about identifying the right kind of occupation. They've generally been satisfied with occupation that benefits the occupier for good reason, because the court isn't, generally speaking, in a terribly good position to draw that line. And we put in our skeleton argument the paper cup example, because that shows that this is an amorphous distinction. So if we imagine 10 boxes of paper cups that are in a property, then on our analysis, if they are there as an overt act of occupation that serves the purpose of the occupier, then they are an act of occupation. But on the billing authority's case that they're asking this court to endorse, that depends upon the content of them and the motive of why they are there. If they are there simply as a flag of occupation, they say they're on the wrong side. If they're there because there's a business that's storing paper cups, they concede they're on the right side because it's macro. And if they're there because a whimsical eccentric believes that they are of value in the future, then I don't know what the answer to their case is. But on our case, none of that matters. What matters is all of that's consistent with the occupation. So the answer, we got into this because my lord's formulation was it has to be for the benefit of the community, and I readily concede that the Secretary of State, who is the author of the conditions, could frame occupation in a way that discounted a small amount of occupation or occupations that were perceived not to be for the benefits of the community, but it hasn't done that.
Or the economy, right? One doesn't fix on the word community, it's expressed very broadly by the Supreme Court.
Yes, but in my respectful submission, the Parliament has made two decisions. It's decided to give that power. First of all, it decided itself in the predecessor legislation to link this to the concept of occupation. And then it's decided to give the ongoing power of that to the Secretary of State. And that's why I say it's relevant to see. So if I can relate it to Ramsay, I'm jumping around a little bit, but this is an important point in the shape of the case. One of the rationale for Ramsay is what my learned friend Mr. Forsdick calls the whack-a-mole principle. In other words, the court needs to take a proactive approach to construction because it cannot be expected, Parliament can't be expected to keep up with the ingenuity of rates avoiders. That's the whack-a-mole principle, I think, in a nutshell. This case, if we think about it, is the complete inversion of that, because the Secretary of State has got the power by statutory instrument to change this if he doesn't like it tomorrow. He's actually actively looking at it on the evidence. He's tinkered with it. He's thought about adding extra conditions. He's thought about limiting the number of resets. And he's not doing that because he accepts the argument that it will create some complexity and confusion in the overall statutory scheme. That's the exact opposite of Ramsay, which is you can't expect Parliament to keep up, but you can expect the Secretary of State to act if the ongoing effect of this is contrary to the perceived policy. I respectfully say one of the reasons why that might not be happening is because the economic conditions in which this play is playing out are starkly different to the economic conditions in which this
I mean,
policy
we were taken to that passage in Ramsay, but that's not the usual way in which the I'm going to refer to Barclays Murphy.
Yes.
Is not the way in which that case is routinely applied. Courts don't sit there saying, well, actually, Parliament could include this in the next Finance Act, which, by the way, in tax cases, they usually have by the time the dispute gets to court. That's irrelevant. It's just a question of applying the test of construing the words to see if the transaction fits the type of transaction at which the legislation is aimed, interpreting that legislation purposefully. I haven't put it as well as it's put in Arrowtown in the famous statement. That's the key test.
yes.
And for myself, I don't think you're really assisted by saying, well, Parliament or a legislator in a Secretary of State could make regulations, could pass legislation. Put it another way, are you saying that Ramsay, or whatever label you apply to it, applies differently to secondary legislation as opposed to primary legislation?
I am submitting that one of the relevant differences that the court should have in mind in the application of Ramsay is the ease with which the distribution of power under the relevant piece of legislation. So here it's secondary legislation and the power lands with the Secretary of State. So I am saying that is that makes the Secretary of State, to use the judge below's word, nimble in a way that certainly in some of the Ramsay cases the court is influenced by the idea that Parliament isn't nimble. So I do say that's a relevant factor. And
I've never heard that argument in a Ramsay.
I'm not sure how many Ramsay cases have involved statutory instruments where the power vests in the Secretary of State to change the criteria.
But there's another difference. If, as my lady says, in a tax case where interpretation of a primary statute is at issue, Parliament can, in the next Finance Act, overrule any decision of the courts it doesn't like, and that's pretty well it under our constitution. But are you saying that in a case such as the present, the Secretary of State has an unfettered discretion to define occupation? So I'm sure that if we were so to hold, the next test case would be to challenge whatever amending regulations were put forward on the basis that discretion is not as wide as that, and then you have a different challenge.
Let me give my lord a very precise answer to that.
Yeah.
The Secretary of State has no power whatsoever to prescribe the conditions of occupation under Section 43. The Secretary of State has absolute power to prescribe what counts as unoccupied a prescribed hereditament for the purpose of section 45. I'll show you why I say that.
I'm sorry, absolute is a very big word.
Well, subject to well the let me use
limits at all.
let me use well there's probably a Padfield limit,
Yeah,
but
yeah,
but
I'd like to think so.
the statute uses the words as he sees fit. So that's a
We're used to seeing that in public law.
yes.
It doesn't mean what it says.
Well, let me formulate the answer.
Yeah.
I don't think that takes away the point I'm making. So I may have overstated by using the word absolute, but let me redirect that and moderate that. No power whatsoever to do anything under the general law of occupation, section 43. A wide discretion symbolised by the words as he sees fit and the class of points under section 45.9. Now it is happenstance that the current iteration of that uses the same concept. That is not a necessary feature of the statutory scheme. That could be changed by the Secretary of State in a stroke of the pen. This court's task, I say with respect, is to construe a scheme that uses the concept of occupation in two places. They have to be used consistently. It's part of my answer to my learned friend's case to say the law of occupation is readily understood. If that produces surprising and disappointing and unattractive effects, change it. You've got the power, just change it.
I mean, sorry.
Can I just ask a small point going back to something you said a few minutes ago? You said it could be a collection of paper cups. Mr. Justice Carr, in one of his two decisions, speaks about a scarecrow with a flag. As I understand it, it's not essential to your argument that we see from the pictures that there were actually rather a lot of boxes, and they took up a substantial proportion of the space, say 70%, could be 10%. It could be nothing except a scarecrow or a flag or a notice saying we Pearl are in occupation of these premises.
No, if I take those in turn,
Yeah.
the many boxes, I agree. The not that many boxes, I also agree, because it would pass the macro slight occupation is occupation. The scarecrow would not be an outward manifestation, an overt act of occupation. So by definition, that wouldn't be that. And the notice similarly wouldn't, unless I could run a Melledew analogy, which I'm not running and I don't claim to be able to run.
And why do boxes differ from the scarecrow?
Because they, my submission is because they satisfy the four ingredients of rateable occupation. If I take them in turn, they're rateable. There's actual occupation. They have a physical presence there. They are there's nobody else is involved, so they satisfy what's called exclusive occupation, which isn't an issue here. They're there. The 6-week period it doesn't fall foul of the concept of transient occupation. And then the one that's an issue in this court is, are they beneficial occupation? I say they are, because they are there as an overt act of occupation which serves the purposes of the occupier. That's the way I put it, and there's no prohibition on it being there. And I do say that
Why isn't the scarecrow?
Yeah.
The scarecrow isn't a well.
I know in the case I think it's referred to as just there as a security measure, but
Yes.
what happens if you just put a scarecrow in the middle of the floor and you say, well, that's occupation. I'm occupying to get the benefit of the rate mitigation strategy. That's it. But doesn't this really illustrate the problem?
Well, it might illustrate the situation. What it illustrates is it's very hard to draw a conceptual line as to what is an occupation of value, save through the established mechanism of asking, is that an overt manifestation of a deliberate occupation? I'm jumping around, but I hope it's helpful to sort of try and take these points heads on, and then I'll go through it in a more systematic way. But my lord's Lord Justice Holgate noticed the when we were talking about intention, noticed the footnote in Ride that I think went to Irith. But the other part of that footnote goes to a case called Hackney, which is cited in one of the cases here, and that the circumstances of the Hackney case were left over in the caretaker's cupboard was a mangle and a mop. Let's say, I'm not sure that's exactly right, but sums up. But that wasn't an overt act of occupation because that was understood as material that wasn't worth anything that had been abandoned. So intention
bypass blighting case.
Yeah, exactly, which applies exactly that line.
Well,
Yes,
he basically left, hadn't he?
yes. He'd left the house, but he put some things in the shed for the purpose of maintenance. And the idea that if you're simply a caretaker, that is not so. So the relevant principles on the established law are being a caretaker is not enough to amount to rate of occupation. Doing something that doesn't read as an assertion of occupation because it's the abandonment of worthless goods is not occupation. But the flip side of that is that if there is an overt act of occupation which has benefit to you and is understood in all the relevant circumstances as an assertion of occupation, then that is legally sufficient. That's what Macro does. That's what poll number 1 does. That's what Mr. Justice Kerr thought was so obviously right that he set out a appendix to make sure there weren't further disputes about this. And the reason why that point was tested in that way was exactly to avoid the idea that a billing authority comes in and inspects the content of the boxes and makes a marginal and really non-justiciable call about where the point of value is. That's something that scheme could provide for really easily, but it doesn't. And there's lots of case law, I say, that goes exactly the other way. And whilst I accept the consequence of that case law feels surprising when measured against the statutory purpose, let me accept that. But that's a direct consequence of what His Honour Judge Jarman said in paragraph 4 of Macro. It's because of the reversal of roles under the current statutory scheme. And back to my Lord Justice Bean's observation, that is not a necessary and inevitable feature. That is a feature that remains under the control of the Secretary of State to unlink that and to introduce a new concept of occupation or a series of limits for occupation under Regulation 5. But they're not doing it.
To try and simplify this, as you rightly reminded us a while back, when we apply Ramsay, Rossendale and so on, the focus is on the language of the statute. That is where we find the purpose. So, as I understand it, the theme running through your submissions and response to a number of questions is that the relevant bit of language that we have to focus on here for that purpose is occupation.
Within Reg 5.
Well, not just within Reg, well, it's certainly within Reg 5, but you also go on to say that occupation in Reg 5 has the same meaning as in the primary legislation.
I do, yeah.
And which makes life less complex than it might otherwise be. But also it's the antithesis of non-occupation.
Yes.
Just wanted to simplify.
And the whole scheme is built around those being binary concepts. And I wonder if it helps if I now just make some points on the statutory scheme. And I hope I can take them quite shortly on that basis because that does help, and I don't dissent from that exchange.
If you're going to embark on a topic or a new list, leave it with you whether you'd like to break off now or make a quick sprint through your next point. It depends how long it is.
Are we going until 15:15? Is that the cut-off?
Usually.
Yes. So no, that's fine. Can I just I think it might be helpful just to show the key provisions, and I can do that in 5 minutes,
Yes.
and I may then come back.
Can I just ask one question, or it leaves you time, I don't know, which is the traditional concepts of occupation and the cases are all obviously at a time when rating depended on occupation.
Mm.
and we have section 65(2), I think it is, which appears to look back, says apply the existing rules. To what extent does time stand still? And what I mean by that is it part of your case to say that the legislation requires a sort of backward-looking approach that continues the trend, if you like, or maintains the point that occupation is interpreted very widely?
So,
because if you were coming, I mean, you wouldn't design a statutory scheme like this from scratch, of course. You probably wouldn't draw the same distinctions between occupied and occupied, but we are where we are. And maybe you can only make sense of the scheme by recognising that previously all that was rated was occupied property.
Certainly unoccupied property is a bolt-on to the scheme.
Yeah.
Certainly it's a deliberate feature of the scheme, which is mostly a scheme about occupied property, that the common law is preserved. All of that is, I would respectfully suggest, uncontroversial. So in that sense, it's backward looking, but I would accept that it's backward looking, but it's capable of being evolved. But what I do say is that the current policy choice that's been made, and it's, as I've emphasised, it sits with the Secretary of State, is not to create a bespoke model of occupation for Regulation 5 that is rates mitigation active. It hasn't done that. So therefore we are stuck with this slight paradox that people have swapped sides, and the billing authority are no longer arguing in these kind of cases for an expansive version of occupation, but for a much more contracted one. But if it's the same law, then the reversal of usual roles should lead to the application of the same concepts until corrected by the Secretary of State. And then, may I then just show the court page 8 of the authorities bundle, if I may. Sorry, forgive me. If we could just go, please, to page 3 first of all. So this is the 1988 Act, and I just want to just tie this up in this way, and then I'll come back to the rest of the provisions tomorrow. But section 43 is occupied hereditaments. As we've seen, section 43(1)(a) is that the ratepayer is in occupation of all or part of the hereditament. So again, the expansive approach is a few boxes in a large warehouse leads to liability for the whole warehouse. That's what that does. And then if we go to section 5, so section 45 on page 8 of the authorities bundle, there's a different schematic answer to section 45, because unoccupied hereditaments have to satisfy 4 conditions, and we're interested in A and D. So on the day, none of the hereditament is occupied, and that's why I say that these two are polar opposites, as my Lord Justice Holgate put it. It's a binary scheme. On any given day, a property is occupied or unoccupied. It can't be both. And then in order, but that's not the end of it. There's then other conditions, and one of them is it's in the class of hereditaments prescribed by the appropriate authority. The appropriate authority haven't got the provision, but in Wales it's the Welsh Minister, in England it's the Secretary of State, and that's section 67(12)(a), which we can provide if it would be helpful, but just to tie that up. And then the reason I make the submission is about what Ramsay applies to is subsection 9. For the purpose of 1D above, a class may prescribe by reference to such factors as the Secretary of State sees fit, and without prejudice to the generality of that, a class may be prescribed by reference to one or more of the following factors: physical characteristics, the fact that the hereditaments have been unoccupied at any time preceding the day mentioned in subsection 1, that's the relevant day, and the fact that the owner of the hereditaments fall within prescribed hereditaments. So there's a very broad power of prescription, and then there's an illustrative set of indicators about like what that might be used to exercise, which are not conducive of the whole scheme. And so that's the key statutory power. You've obviously got section 65(2) that you're familiar with, and that's the primary legislation. I'm content to break there and to pick up
4A based on section 4510B.
45(10).
The one you just took us to.
Well, 45(9) and then
Yeah, it's obviously 9 as
yeah.
well. It's 10B.
yes, I think
it's specifically referable to 10B.
I think that's right. I think that is right. Yes, yeah, which is within the broader ambit of 9. Yes, I think I accept that. Yeah. Is that a convenient moment? I'll then pick up the 2008 regulations and I'll continue with my submissions.
Yeah.
Thank you very much.
10:30 tomorrow.
Rise if able.